Hi, everyone. My name is Richmond Brodigan. I'm the Senior Symposium Editor. Once again, if in case I'm repeating myself from earlier. But our third session begins, of course, with the familiar premise or pillar of international law that the notion of sovereignty, which is, you know, accompanied, of course, with the conception of the right to exclude. The, you know, those who decide who get to enter and who must leave. In practice, that authority is often enforced through, a variety of methods, through punishment, detention, deportation, criminal prosecution. And across legal systems, this justice is frequently framed in retributive or even punitive terms. But the law doesn't, of course, have to be framed this way. This panel asks, what happens when we question the assumption that accountability must look like retribution? Participatory defense movements and participatory law scholarship press on that assumption. They shift attention away from the state as the sole arbiter of harm and towards the communities that are directly affected by enforcement, and ask what repair and redress might require under different terms. Now, Elora Mukherjee, professor of law and director of the Immigrants' Rights Clinic at Columbia Law School, unfortunately could not join today. She was called away just in the last day or so to prepare emergency habeas litigation on behalf of a detained family in Texas. So, the urgency of her work really speaks directly to the pressing stakes underlying the subject of this conversation, and we're nevertheless very grateful for her, for the work that she's doing. So that said, we are still very pleased to be joined by Yvette Borja and Rachel Lopez for this conversation. So Yvette Borja is the Laura E. Gomez Teaching Fellow at UCLA School of Law, where she teaches Latinx people and the law. Her work focuses on the movement Lawyering and Immigration Justice. She previously led the National TPS Alliance's legal strategy at the National Day Labor Organizing Network, and produces and hosts Radio Cachimbona, a law and politics podcast centered on race, social movements, and border issues, with particular attention to the Central American experience. And I've been told that this may or may not be an episode of that aforementioned podcast. She holds a BA from Yale and a JD from Stanford Law. Next to her is Rachel Lopez, who is the Barak Chair in Law at Temple University, where she teaches and writes in international human rights, criminal law, and transitional justice. She is the originator of the Participatory Law Scholarship and a Fulbright U.S. Global Scholar. Her work has appeared in leading law journals, and she has testified before the Office of the United Nations High Commissioner for Human Rights and the Philadelphia City Council. She also co-authored Human Rights Advocacy in the United States, the first law school textbook focused on domestic human rights in the US. She holds a BA from Northwestern, a JD from the University of Texas, and an LM in French and European law as well. And so with that, I'll leave it over to them for our third panel. Give it up.
Thanks so much, Richmond. I wanted to thank you and all of the student editors at the NYU Journal of International Law and Politics. It's been a pleasure working on this article with you all, and I wanted to thank you for seeing the value of my work. Also wanted to thank my lovely co-panelist, Rachel Lopez, whose framework around participatory law scholarship has really helped me in evolving my own scholarship. I'm just really grateful to be here with you all today. Don't take it for granted, and thank you for your time. I appreciated the title of this panel a lot, Rethinking Responsibility, Community Advocacy, and the Practice of Justice, because the question of rethinking the responsibilities of deportation defense lawyers is really what animated the piece that will be forthcoming in the journal, Participatory Deportation Defense, Becoming Abogados de Confianza. And I wanted to think about how we would rethink the responsibilities of deportation defense lawyers if we took seriously the legitimating role that they play in the horrors of the ever-expanding and unprecedented scale of immigrant detention and deportation within the US. In this project, I'm expanding the discourse around right to counsel, which has thus far focused really on public defenders within the criminal legal system, and am applying many of the same critiques that have been lodged against public defenders against deportation defense lawyers, in particular the ways in which defense lawyers normalize or normalize the routine injustices that occur within these systems, and how the right to counsel can also obscure all the ways that due process is actually denied to people in deportation proceedings, and how those who champion the right to counsel can potentially obscure the ways that due process is actually an impossibility for people who are detained and fighting their deportation cases. I thought that this project was particularly relevant in this moment where more and more DHS is failing to abide by its own regulations, let alone the Constitution. Defense lawyers are most effective in a system where rule of law actually exists. Defense lawyers are not so useful in a context in which the rule of law does not exist. And I think DHS and the way that it operates is it's operated outside of the bounds of law in the past and is getting much more comfortable doing so in the day-to-day. I have to, I guess, admit that part of the inspiration for this article was my reflection of my own time as a legal orientation program attorney at the Florence Immigrant and Refugee Rights Project, where I provided counsel to pro se litigants, people who are unrepresented in their deportation proceedings. And it was there that I saw firsthand how a program that was designed to increase access to counsel and that was sold as a way of increasing access to counsel can actually create a situation where the majority of people who are detained are still denied full scope legal representation. But this legal orientation program sort of papers over or justifies that fact and makes the appearance of due process, makes it seem as though there is due process when in actuality there is not. But the piece is also inspired by my time as a participatory defense organizer in Tucson, Arizona. I co-founded Red de Defensas, a participatory defense hub there. And it was through those experiences that I was able to see what immigrant empowerment might actually look like. The irony of the legal orientation program is that it was initially thought of as a way of empowering people who are unrepresented, but I found that it fell much too short and find the participatory defense movement to be a much more effective means of empowering undocumented people as they fight their deportation. The insights that were gleaned from this article come from participatory defense organizers themselves, from undocumented people themselves, and I'm arguing that they should be thought of as an authoritative, interpretive community in regards to what effective counsel looks like. And in speaking with them and in working with them, I found that they wanted lawyers who were willing to engage in non-traditional means of legal advocacy. They wanted lawyers who were willing to act as legal observers at protests or coordinate them, who were willing to coordinate court watch projects, to begin to have the broader public have a better understanding of the regular due process violations that occur within the immigration system. And they wanted lawyers to democratize their legal knowledge. They didn't want lawyers to keep the knowledge that they have to themselves. They wanted it to be dispersed within the community, which is also very critical in a place like Southern Arizona, where there is a dearth of free immigration lawyers. And so these different approaches all sum up what the framework that I'm introducing in the article, which is abogados de confianza, which translates to lawyers that people can trust. But I'm discussing specifically lawyers that participatory defense organizers and undocumented people can trust. And this, I think, is where the work ties in really nicely with Rachel's scholarship, because I think the connection between participatory defense and participatory law scholarship is that both center the knowledge and experiences of directly impacted people and see their knowledge and experience as critical to charting forward strategies and pathways for reforming these systems, either reforming them or coming up with alternative systems of accountability, which I think is a little bit of what Rachel's going to talk about. So yeah, I think that's a good introduction. I think I'll just end by saying that the title of the piece is Becoming Abogados de Confianza, because I do think that being this type of lawyer is an iterative process that requires constant reflection of what people need and also what's needed in this particular moment. I'll pass it on to Rachel.
Thank you so much. Yvette, I just want to start by acknowledging this incredible piece that you are about to publish, and also underscore a bit what I think the students who picked it probably understood, which is it's such a for us that are sort of doing this work on the ground, so important to not get pushed into the cogs of the wheels. And I think your piece really gives a vision for what this alternative framework of being a lawyer vis-a-vis creating space for more legal imagination could look like. And so I'm so incredibly honored to be here in conversation with you. And I love the parallels that you're drawing between our work. And I want to thank you so much to the editors and all the staff for inviting me here today. I had hoped to be joined by one of my co-authors, Kempis Songster, but regrettably he was not able to make it today. You'll bear with me because some of my remarks or answers to questions will try to bring in the knowledge really of my co-authors as part of this process. But before I get there, I just want to kind of start with the starting point of participatory law scholarship. So the starting point really is actually deeply connected to Yvette's understanding of why we need abogadas de confianza, which is that lawyers and even legal scholars often recount the stories of others to support their own legal arguments, but rarely cede legal spaces for those who have borne the bluntest consequences of law to tell their own stories. And I have a really starkly different approach. And sometimes I hesitate in a room full of lawyers or would-be lawyers, soon-to-be lawyers, to talk about sort of what undergirds this. But part of my methodology and framework is really oriented around this idea of making lawyers less important, which I think we share and is a common thread. What do I mean by this? I think that we must find ways to build capacity for those not formally trained in law to advocate for themselves in venues typically reserved for lawyers. In my context, for me, over the last 4 years, this has taken the form of building a new genre of legal scholarship called participatory law scholarship, which I define with my co-authors as legal scholarship, which is written in collaboration with those who, though not formally trained in law, have expertise in laws and justice through lived experience. And this approach really raises a lot of the same questions that Yvette is tackling in her piece about who produces knowledge and why, and what role lawyers should play in facilitating a social change in the material world. And to tell you the story of PLS, I would be remiss not to start from the beginning, which is the first participatory law piece I wrote called Redeeming Justice. This piece, basically in 2019, I was working with a group of men that formed a think tank in a state prison outside of Philadelphia. We had been brainstorming ways to effectively elevate a concept that they had collectively conceived, all of them serving life without parole sentences, that the underlying motivation for this being that they believe that no human being is incapable of change and atonement, and that this should be reflected in the law through the adoption of a right to redemption. And they expressly conceptualized this as a human right, which as a human rights scholar really was something that was very moving to me. And we had really developed a litigation strategy around this, and we're trying to build out, really in the spirit of abogadas de confianza, this idea of how do we elevate this sort of analytical framework that was developed from behind bars. And we had a strategy, but then COVID hit. And that basically shut down entirely what we were able to do. I was working with a group of students, we could no longer meet with our colleagues that were a part of this think tank. And so everything pretty much halted. And I was trying to think about ways that we could bring this work forward. And sort of serendipitously, I shared an article that was in part inspired by the work that these men were doing as hospice care workers behind bars. It's an article called The Unusual Cruelty of Nursing Homes Behind Bars, and it was about basically the rising tsunami of the elderly incarcerated. And I shared it with my other co-author, Kippis Songster, who was supposed to be here today but wasn't able to be ultimately. He was released, he was sentenced to life without parole at 15, was released in 2017, and so we were coordinating advocacy efforts on the outside, and I sent him this article, and he reflected back to me, where is the humanity in this piece? He didn't say it so bluntly as I just said it, but that was clearly the message that he was conveying to me, that somehow, through my legal ease and conception, I'd really done a disservice and stripped the humanity from the very people that we were trying to lift up as part of our work. And that really got me to reflecting, well, what if we were to write together, all of us, the chairman of the think tank, Ghani and I, an article surfacing the right to redemption. And that ultimately is what birthed Redeeming Justice. Now, I sometimes like to point out, and I think it's a good context to raise this, when we first tried to publish this piece, not a single journal made us an offer of publication, literally not one. And I had wondered myself, did I encourage my collaborators to do this, and I was deeply disappointing them. And then something very strange happened. Justice Alito came to the rescue. That might surprise a bit of you. But interestingly, in a case called Jones v. Mississippi, he asked a question that was at the heart of our article. He asked this question to the petitioner, who is actually a clinical professor at Northwestern. Are there some people that are incapable of redemption? And this was effectively at the heart of this article. And so we oriented our article around answering Alito's question, and posted it the week after this oral argument where he made this statement. And this was back in the day of a more robust Twitter, when Twitter was called Twitter, and it sort of went viral in a way that was completely unexpected for us. It resonated in a way both on all levels with people who were directly impacted. The sort of editor, one of the editors of the Washington Post retweeted it, and it galvanized this sort of odd consideration of this concept that was birthed inside by my co-authors. And we can reflect a little bit on why it took a justice of the Supreme Court to ask a question for that to happen. But one of the messages here I think that's really important is this idea of recognition of knowledge produced by those that are bluntly experiencing it. And an admission on my part that I had heard of the right to redemption for a long time before I ever really took it seriously. As a human rights practitioner, I was like, there's no right to redemption that exists. When I first learned about it, when I met Ghani in 2014. And then I slowly learned through the research that I was doing with this group that in fact the European Court of Human Rights had adopted the right to hope, which was a right that they accorded to people who were serving life without parole sentences, believing that effectively that all people should have the right to hope, meaning that they should be able to believe that they can atone for the wrongs that they commit, such that a life without parole sentence that forecloses the ability of review and release is a violation of human rights. Now, the most interesting part about that jurisprudence is it was after the right to redemption had come up with this framework separately behind bars. And so part of the article of Redeeming Justice was really surfacing how these two separate bodies kind of both organically came to the same conclusion, maybe using different language, the right to hope on one hand and the right to redemption on the other, but really underlying the same concept of this fundamental belief and redemption. Now, of course, we have lots of skeptics, and I'm sure you faced some skeptics to your work as well. So very interestingly, when we put the article out, the next time we got a bunch of offers, ultimately was published in the Northwestern Law Review. We won the Law and Society Article Prize for that year. And so an article that really almost got no attention suddenly was getting all this acclaim. But even still, of course, we had our detractors. In fact, someone who I will not name basically wrote a piece effectively saying that this was scholactivism and that this was a violation of my obligation as a scholar to pursue truth because I was engaging with activists and this somehow was polluting the academic enterprise of scholarship. And you know, a piece of this really is grappling with that epistemology. Who has the right to produce legal knowledge? And my contention is that it's critically important for those that are actually experiencing the most acute effects and even harms of law to, much like Yvette says in her piece, brainstorm ways the law needs to be reformed and transformed. And this is really sort of, as I mentioned, birthed this idea of the participatory law scholarship movement, which in a way kind of, in ways that we just never expected, has now kind of galvanized this movement of people that are using this methodology from everything from immigration to disability rights. And it's now in a way that almost felt, especially when we didn't get an offer the first time on our first piece, we just never felt that it would be recognized in this way. And the most interesting part about this is, you know, a lot of people, I think, were skeptics about, well, why does this even matter, right? Why would it even matter to listen to these people? Well, a piece of this was the movements that it galvanized. And this is a story that I haven't told too much publicly, but there was a coalition of advocates that formed in part inspired by Redeeming Justice that now have successfully petitioned a number of UN bodies using the language, and I should have mentioned this, my co-authors called Life Without Parole death by incarceration, so another form of the death penalty. And now 3 different UN bodies have referred to life without parole as death by incarceration and recommended a moratorium on death by incarceration in the US. So what seemed sort of completely marginalized has now become vernacular even at a global level, starting way back in SCI, Greater Ford outside of Philadelphia.
Thank you, Rachel. That was so great. And there's so many threads of what you just said that I want to pull from. But I think one thread that connects our work is, as you've mentioned a few times, is this question of who gets to produce knowledge and who gets to produce knowledge that's worthy of judicial attention, of legal attention. That's something that definitely animated the Abogadas de Confianza piece, because we've heard from judges, we've heard from lawyers about what effective counsel means, but have we actually asked undocumented people themselves what it is that they want their lawyers to do? And I think that the answers to the question surprises many lawyers. I have gotten pushback from them saying, well, we're trained in this specific way to do these specific things that are needed right now, so shouldn't I do those specific things? I'm so busy. I don't have time to go to the protest. I don't have time to organize Court Watch. And I think my response to that is that an abogada de confianza is somebody that takes the knowledge and experience of their clients seriously. And that also, I think that this is critical for any lawyer that wants to be a part of the participatory defense movement, because especially in the world of billable hours, I think unfortunately lawyers internalize this idea that their time is more valuable than other people's time. And that's why there's, quote, no time to go to the protest or no time to coordinate court watching, because they have to do this other more important thing. And I think if an abogado de confianza is somebody that is working to upend the power asymmetries that exist currently between lawyer and client. And if you're not willing to give your time in order to do that, you're never going to get there. You're never going to get to that trusting relationship that I'm arguing is necessary to be an abogado de confianza. The other thing I'll note is that the scholasticism critique, I think, is an interesting one. And I see myself as being positioned within critical immigration legal theory, which is a group of scholars that do see themselves as blurring the lines between what a scholar is and what an activist or organizer is. I very much feel called to that group of people and to that mission. And I think it's the fact that it's caused such an upset within the legal academy, I think shows the power of the disruption of it and how much it stands to threaten the status quo, but I actually think that that's exciting. So I wanted to ask you, Rachel, you mentioned the Redeeming Justice piece, but I know that you're also doing a work in progress co-authored with Meredith Elizalde, and it's centered around an accountability process that Kempis led. So I wanted to ask more about that accountability process and how writing about that process inspired you to rethink what you call punitive victimhood.
Thank you so much. So just a little bit of maybe background about this new piece, Restoring Justice. So it's really, in some ways, the flip side of the coin of redeeming justice. So, the right to hope is squarely, as articulated in the European Court of Human Rights and also by the think tank, a right that is vested in incarcerated people serving death by incarceration sentences. And an often question and pushback that we got when we brought this work out, even in that Twitter post that I mentioned earlier, was, well, what about the rights of victims? What about them? Are they, don't they have their own rights? And this piece really interestingly also organically came up as a response to that question. So my co-author, Kempis Songster, who also was my co-author in Redeeming Justice, is now a restorative justice practitioner. And he led a process with my other co-author, Meredith Elizalde, whose 14-year-old son was killed at a mass shooting at a high school. She decided that she wanted to pursue a restorative justice process, and that basically effectively found that the criminal legal process through which that she was enmeshed in really dishonored the legacy of her son. She talks about it as being worse than his funeral, because he was not centered in the process. In fact, he was just referred to as the decedent. They didn't even mention his name. And it was really the people who killed her son who were at the center of these processes and not her own son. So she decided to pursue a restorative justice process that, as I mentioned, Ghani led. But one of the challenging pieces of this was that there was no supports for this process to happen. Victims' rights, and this is what the piece centers, both in the US and under international human rights law, really only accords rights to victims to the extent that they want criminal punishment. So part of what we lay out in this piece, the punitive victimhood concept, is this idea of understanding of victims as only being recognized as such and accorded rights when they are actively seeking criminal punishment. So in the US system, what this means is that victims only have rights to the extent vis-a-vis the criminal legal process. And even when it comes to rights that on their face seem like they would be disconnected from the criminal legal process, such as rights to compensation or restitution, or even the rights to certain immigration status, if you cooperate, you can only get that if you cooperate with police. And so effectively, it's only according rights to those who, unlike Meredith, want criminal punishment. Similarly, under international human rights, which is maybe more relevant for this group, there is a criminal sort of turn of human rights law. I am certainly not the first to say that, but the contribution of this piece in particular is to show how this obligation to have criminal punishment after human rights violations is tethered and justified by victims' rights. So if you look at the jurisprudence, they justify it by the victim's right to truth, the victim's right to an effective remedy, and the victim's right to justice. And so Meredith in herself is a living rebuttal of this presumption of punitive victimhood. And really part of what we want to discuss here is alternative forms like restorative justice that effectively the kind of core message of this is that all of these systems are built under the premise that all victims want punishment. When in fact we know that both because of Meredith, but also because of the empirical evidence that we marshal in the piece, that is not the case. So why are we then building legal structures around that presumption is the message. And so we are proposing a human rights to restorative justice that recognizes that restorative justice for some victims is a more effective remedy and a better avenue for truth. Maybe at some point I can talk a little bit about how Ghani articulates how actually the criminal legal process undermines the ability to uncover truth.
Thank you, Rachel. What I thought was so powerful about your piece, and it's a very important contribution to abolitionist thought, is that I think the accountability process itself, with Kempis at the helm and Meredith as the person who wanted to go through this restorative justice process, complicates our binary understanding of perpetrators of harm versus victims of harm, because Kempis is someone who, yes, perpetrated harm and is now in this a different position where he's leading an accountability process that is leading to healing for this person. And I think part of the punitive focus within the criminal legal system is this binary thinking of someone is either a perpetrator of harm or a victim, and the specific rights attached to both of those identities, and there's no understanding of the fact that all of us have the capacity to inflict harm. And once we sort of start from that premise versus the current premise of criminals who do bad things are the people who are in the system, and so since they've done a bad thing, I don't care about what happens to them. I think having a realization of the fact that all of us are capable of perpetrating harm, and also that all of us are capable of redemption, is critical to getting us out of this frame of punitive victimhood that you so eloquently describe. I wanted to know if you could elaborate a bit on, because you outlined really well how the current carceral system doles out rights to victims only insofar as they're interested in punishment. Can you outline how that current framework actually fails to meet victims' needs and how it failed to meet the needs of Meredith?
Sure, though I want to be sure to engage with your work more. So let's maybe I can ask you some questions after. But yeah, I wonder if this might be a good point to bring in some of the words of my co-authors to understand a bit more about their perspective. And so maybe just to talk a little bit about, maybe starting with Kempis Songster, or he's affectionately known as Ghani's perspective as it relates to truth, and why he really understands, basically, in contrast to the international human rights jurisprudence, which again justifies the mandate for criminal punishment on the right to truth, the ways in which actually criminal punishment eschews truth. So this is in Ghani's words from our piece. From the first moment you encounter the system, the very first thing it tells you is anything you say can and will be used against you. And your lawyers tell you the same thing, to keep quiet. And before prison, the street codes taught the same thing: never tell on yourself, never admit wrongdoing. They both send the same message: if you tell the truth, it's going to cost you. But accountability and healing both begin with truth-telling. There can be no accountability without truth, and no healing without accountability. Yet the legal system from the outset makes truth-telling dangerous. So you can see in this that kind of undermines this framework of the right to truth being tethered to criminal punishment and shows the ways that actually it inhibits truth from Ghani's perspective. I also maybe just want to give you a sense of what the process looked like, which was one of your questions as well, from Meredith's perspective, and what, well, actually, maybe a little, just say a couple words from Meredith about why she wanted restorative justice. So this is also to quote from her. She says, "Being Nick's mom, that was her son, was the greatest honor of my life. The second greatest honor was holding him as he died. I loved being a mom. Nick is my only child, so his murder caused me to lose him along with my motherhood and identity. I miss being a mom in the ways that I knew for 14 years, and I can't fathom a life where I'm not Nick's mom, so I now parent his spirit. And I see it as part of my maternal honor to engage in restorative justice, just as Nick would have wanted me to do." So she really sees this as a way to center Nick's legacy, and part of the process, you know, for her, why this really was more effective in terms of entering a journey of healing was that she was able to meet with the boys and tell them about who Nick was and really get their assurance that they wanted to continue to build on Nick's legacy. And for her, that meant much more than any prison sentence. But an important thing to note is that there was no formal sanction for this. So basically, as Meredith talks about in our article, they had to do this in silence. So this is what she talks about, her reflection of what this experience was like. "There was no official pathway for what I was trying to do. I had the support of a few individuals in certain institutions, but no formal approval or a judge to facilitate access. We were always at the mercy of gatekeepers and shifting permissions. There was no court-supported process or sanctioned restorative setting or understanding that healing could coexist with a criminal case. We carried fear that if the judge found out, the entire effort would be shut down and dismissed as inappropriate within the realm of the criminal legal system and treated as interference. So we moved quietly. Because there was no formal restorative justice space, the meetings happened in jail, inside the very architecture of punishment. I remember how unnatural it felt to enter a place built for cages and control while trying to create a moment of humanity, truth-telling, and repair. It was hard for everyone. The walls, the uniforms, the fluorescent light, the locked doors, the handcuffs, and the constant noise all signaled separation, suspicion, and shame. Yet inside that environment, we were trying to do the opposite, to speak truth, to feel what was real, to hold unbearable grief alongside accountability, and to find even a fragment of relational grounding. It was not what restorative justice was meant to look like, but it was the only way we could do it. So you see in this sort of the ways in which there is no, because of the way that our legal system is structured, there is no pathway for people who want to engage in this process to do so. And it's forced to be in a carceral setting that actually undermines the very motivations for the process. So maybe I can turn to you and ask you some questions, because I really enjoyed reading your piece. And one of the things that I think is so interesting about your piece is the ways in which you kind of connect it up with abolition and make this connection of, okay, well, if we as lawyers identify as abolitionists, sort of how do we use our role as lawyers? And I think that's a very tricky line to draw, right? In the sense of, you know, abolition, I do take, as you do, right, Ruth Gilmore's call that this is about presence and not absence, but it is very much about, you know, to some extent, removing the harmful consequences and even the legal rules that bound that. And I wonder, I guess, part of my question for you is, to some extent, our rules of professional responsibility almost force us to be cogs in the wheels. So what I'm thinking about in particular is, you know, there's rules around attorney-client privilege and confidentiality, right, that can get in the way of a more movement-oriented framework for lawyering. And I would love to hear a little bit more about how lawyers can operate within the rules, or when you think it's okay to go outside those rules in the spirit of being an abogada de confianza. And then maybe secondly, part of the oath when you become a licensed attorney is that you vow to uphold the law, right? And to some extent, an abolitionist spirit and truly operating in movement spaces may come into conflict with that when the law is fundamentally unjust. And so I'd be so curious to hear your framework for navigating those tensions.
Yeah, thanks so much, Rachel. The framework for abogados de confianza definitely conflicts with a few professional rules. And I didn't touch on it in the piece, but hope to explore in future scholarship changes to those rules that would allow people to be abogados de confianza without having to worry about violating professional ethics rules. And I think the attorney-client privilege tension for someone who's a movement lawyer and advising not just their client, but also, let's say, Red de Defensas or like the orgs within the social movement as well, is a tension that definitely exists and something that an abogado de confianza would need to navigate. I think that what I've found is that this tension is a bit more, it's maybe more theoretical than actual. At least that's been my experience, just in the sense of, let's say someone is being supported by a participatory defense group. The group wants that person to obtain legal relief, to stay in the US, and to continue being a community member. So they're usually not advocating for a position that would require that person to do something that would put their immigration case at risk, let's say. And oftentimes, when you are an abogado de confianza, there are more traditional legal roles to play, habeas filing for one. But oftentimes, if you're deeply embedded in the group, it's oftentimes less so doing direct legal representation, but oftentimes more counseling the group on how to avoid legal liability, particularly in these times where the administration is very blatantly prosecuting people, nonprofit organizations, and humanitarian aid workers. And so I found that I haven't encountered a situation where I genuinely feel like there's a conflict of interest between my advice to the client and what's best for the group as a whole. And that's because the goals of the group as a whole are generally aligned with the individual, which is like they want them to win their immigration relief and they want them to stay in the country. And then if there are ever times in which somebody in deportation proceedings needs to take a risk, then I think that is where like the really critical attorney-client privilege sets in, and where you do need to advise your client about any potential negative repercussions that could happen from them attending the protest or from them speaking to the media, et cetera. I think it's a tension that exists, but I found that in practice it doesn't create too many obstacles, actually.
That's really interesting. Maybe I don't know if folks from the audience have questions. I definitely have more questions for you if not, but I don't know if we should open it up.
Yeah, let's open it up if folks have questions.
First, I just want to thank you. This has been amazing. I'm taking lots of notes, and I'm looking forward to reading your piece. Thank you so much. I'm interested in kind of this question that you asked about what to do as a lawyer, and including as a movement lawyer, when the law is unjust. And it's something I'm thinking a lot about. In particular, what is the role of the lawyer in resisting autocracy, et cetera? I feel like there are answers in the idea that people who are the targets of injustice kind of know the answers. They know the new definitions, they understand what they want from lawyers. And I'm curious if you are thinking about it also as a resistance tactic to autocracy at this moment, because it strikes me that this epistemological kind of intervention is really crucial right now. Just wondering your thoughts there.
Yeah, so I do struggle with answering these questions of like, what do you do when people are breaking the law? Because I like don't want to be on record saying, you know what I mean? But yeah, I think a lot of the situation that we're in was actually created by lawyers, and I think a big reason for that is that legal education doesn't ask these questions of what do we do as officers of the court or as representatives of the legal system when it is authoritarian, when it does take an autocratic turn. That's just not contemplated, and I think people feel very uncomfortable because our current role is to uphold the legal system as it exists. But I do agree with you that in this moment that lawyers do need to find the reflection skills within them to discern whether the rule of law exists, and if it doesn't, then I think it is appropriate to, especially to use your voice, one that will be taken seriously in analyzing the law, and say, this doesn't follow the rule of law. This is fascistic. This is an authoritarian turn. And I've actually found that immigration lawyers are the ones who are most willing to do that. They've kind of been sounding the alarm on how messed up the immigration system is for a very long time, more than lawyers from any other subfield. And I commend them for that and think that we need to celebrate that. And I think ultimately think about it, because I think the people that do that and speak out right now are actually preserving our democratic nation state, like to the extent that it still exists. And I think that that is a critical role for a lawyer to play. So I think that lawyers should push themselves to do that.
Yeah, I've been thinking in the same way that you are, and really thinking about this idea that Robert Cover, a famous scholar, illuminated, and it is just in one little line in his article, Nomos and Narrative, where he talks about a jurisprudence of resistance. And so part of like maybe my summer project is really going to be explore what does it mean to have a jurisprudence of resistance. In other ways, how can we use the law or perhaps alternative imaginations of the law to combat situations when the law is unjust. And I think there's a variety of ways that this can work. One of the ways really is the centering of people that are directly impacted. And so Robert Cover, in that famous piece of his, talks about these communities. There's a variety of examples he gives. Some are like Mormon communities, some civil rights communities, and the way that they develop sort of their own understanding of legal frameworks to guide their work. And I think that this in itself can be resistance, right? This idea of, and that's part of what I'm trying to cultivate in this work, is a space where people who are directly impacted outside of the context of having to advocate for their own cases, which I agree is really important, but I think there's a freedom in legal scholarship, even though I know people will balk at that, but there's a freedom in the sense that you're not sort of advocating for some sort of specific outcome to some decision maker on high. And there's a freedom to explore alternative frameworks, much like we're doing in this piece, that can set an example. And there's this concept in epistemic injustice called hermeneutic injustice. What that means specifically, it's an idea that basically people who are most marginalized are not able to have access to the vernacular, the language that helps them to organize. And I think the right to redemption is a really good example of that, right? Because effectively, when we talked about death by incarceration and the right to redemption, it had immediate resonance, and this coalition emerged. And that sort of, as I see it as part of like this jurisprudence of resistance and a way of kind of developing a more just framework for how to understand how we engage with the law, sometimes engaging directly with the legal systems and drawing from their foundations, but sometimes completely outside of that.
Thank you both. It was super fascinating. I wanted to sort of share a thought following up on Meg's question. I think if you think about participatory scholarship, et cetera, then there's something that the lawyer would bring to this participation as well. You're not just echoing out the thoughts of people incarcerated or people who are facing ICE or in detention or whatever. The point is that we also have the power and the skills, and that is what we bring to the meeting, right? To translate what is happening into legal tools and legal languages, not only translate outside, right, what maybe our clients would like us to translate, but also to make things present for them and to see what avenues they would have for redress through these systems. And I think the law is rarely one thing, right? You could, as you said, it's not just about protesting against immoral law, but about reimagining what law is said to be by government officials. We might understand it differently, and maybe we have a better argument to make. So just a thought more than a question.
Absolutely. I can sort of maybe just like a quick response to that, which is I think that's sort of like the methodology of participatory law is really this meeting of the minds, and most of it really is engaging. And the spirit actually through which I came to this was in the space of sort of a abogado de confianza, right? It initiated in this way. And a piece of this in terms of the methodologies, I think this like deep listening to what's already being said. And my role as I see it, my co-authors call me a seamstress because they sort of see me kind of pulling not just their narrative, but sort of like their intellectual framework and mapping it onto existing law. And that's really how I understand my role in this. It's not to sort of come up with my own ideas and use their stories to facilitate my argument, but rather to use my tools as a legal scholar to craft a framework and a broader vision that can be legible to all kinds of people.
Yeah. And I'll just say that it's maybe controversial that I say that there's a role for lawyers to play in participatory defense or in support of these movements, because participatory defense started as a whole movement to decenter lawyers from these processes. But then I think the participatory defense movement itself, and then also myself, got to a point of realizing that people are still in these legal proceedings, even though the advocacy that people are doing is much larger than that, and that, you know, we can win much more effectively if organizers do have a good relationship with a lawyer who is willing to pursue their strategies. And I think that there is a tension that you have to walk being a lawyer, because you already come in with power and privilege of people thinking of you as the arbiter of legal knowledge. And you have to sort of, it's a tricky balance of not being overbearing, but also not censoring yourself or not like actually sharing the knowledge that you do have. Because I think that did happen, or that there have been certain conversations, I think, around the position of lawyers that has caused some lawyers to think, well, I should just not engage in social organizing at all because I hamper it. And I think that that's not, well, I think it can definitely be true, and there's historically documented instances of it being true, but it's not necessarily true. And I think that's what sort of why I also brought up like investing time into these groups and these relationships and doing the things that participatory defense organizers think it's important for you to do as a lawyer, so that you can move away, you can be thought of as another participatory defense organizer and not the lawyer in the room. It's a very tricky dance, I'll say.
I just want to thank you both for being here so much. It's so fascinating to hear you. I'm actually one of the senior article editors for JILB. We loved your article, and we actually, one of the reasons why we were so drawn to it is this on-the-ground lawyering that I think is very hard to get a real honest glimpse at in academia. And so one of the questions we were thinking about when doing this, especially coming across this abolition movement, is one, can lawyers really be a part of the abolition movement in the future? Do you see it as kind of almost dismantling the role of the lawyer in all of this, or is the lawyer still going to be essential? And then the second question I had for you guys is, how do you think your perspective working on the ground in the thick of these issues, being so close to the conflicts, informs your own academia? Because you really are in the thick of it, so to speak. You are not, and I say this as an academic who is very privileged to look from the outside, and not necessarily be in the thick of it, how this informs your perspective.
Yeah, so yes, I love the idea of this an abolitionist movement being one that's moving us towards a place that dismantles the need for lawyers altogether. One of my immigration law mentors, Jehan Romero, told me that the best deportation defense lawyer is the one that's trying to work themselves out of a job. So the one that's trying to abolish the detention center, to end the deportation system so that one day, like, there is no need for a deportation defense lawyer. And I think that there is something to be said about the creation of an immigration system that doesn't need an expert to aid someone in filing for legal relief. Like, I do see that as a much better way of running things. And then in terms of my proximity to organizers and how that impacts my scholarship, I mean, I think it totally informs my perspective and the work that I do. I think it's not always valued within academia because there is just, we were talking about this with like the scholasticist critique. There's long been this idea of the scholar as operating from outside of, as necessarily operating outside of, and there's a question of whether or not someone can be impartial while also being deeply embedded. And I'd like to think that my scholarship is showing that, yes, you can be. But I know that that is a critique that people lodge. And I mean, I just really appreciate the student editors because I think a few of you all have expressed that it is the on-the-ground experience that made the piece more compelling. And I believe that to be true as well. So I think we just have to convince the rest of legal academia that that's true.
Yeah, I mean, it's so, your question really gets to the heart of so much, not just in how we understand as academics and as scholars, but in how we teach the law. So I'm teaching criminal law right now, and part of my methodology, in part in response to the way that this scholarship has illuminated my understanding of the law and enriched my understanding of the law, is to bring my co-authors into the classroom and to talk about the cases that we are studying and how sort of this translated in their real life experience. And so just by way of example, this week we covered, did you guys remember Winship? Did you guys cover this case? It's basically a case that says that the prosecution has the burden to prove beyond a reasonable doubt all elements of a crime because of the presumption of innocence. And my co-author, Terrell Carter, actually did go to a trial. It's very rare in the criminal system. Most are through pleas. And he talks about feeling the presumption of guilt as opposed to the presumption of innocence and what the experience was like, not just in terms of like the way the judge treated him, but the way his own counsel treated him. And again, in line with, I think, Tamar's question about connecting the lawyer's role, I have a public defender who was, he's actually the dean of where I used to teach, who was a public defender at the same time that Rel's case went through the system, and is able to map effectively why Rel's experience is not an anomaly. So he had a court-appointed lawyer that was paid a flat fee. He only met his attorney twice, once for 45 minutes before his trial. And and he convinced him to waive his right to a jury trial. And what my courtroom colleague is able to contextualize is this idea, well, actually, there was this trading that was happening by court-appointed lawyers where they would put minimal effort into their court-appointed clients to get the fee and try to win favor with the judge to get the process as quick as possible. And the sort of written rule or the norms was that judge would be more lenient in the future for a paying client. And this was like an ecosystem that existed in Philadelphia around court-appointed lawyers. And so this is like a very vivid understanding of how the legal system works that undermines actually the plain language of Winship, which if you just read it, you think, well, we have a fair system, right? It's based on this presumption of innocence, and there's this huge burden on the prosecution, but that doesn't actually map onto the experience of people that are encountering it. And so part of, I think, the message to me, to my students, is that you cannot understand the law by just reading it on a page. You have to get in the trenches and understand how real people are experiencing it in order not just to understand, but also to be better lawyers.
I think we're at time, right, Richmond? Oh, is there, sorry, I don't want to cut off questions. Is there a last question?
No, it's just a suggestion. Thank you very much for the project. I think it's really great. I just encourage you to insist on the comparative perspective. So you mentioned the ECHR, where like which prohibits permanent sentencing because it's considered as like inhuman treatment. But you should perhaps do a little bit of comparative constitutional law. For example, we have a principle in French constitutional law, which is called like necessity principle, which prohibits those kind of punishments. And same in Germany, there's like a principle which was created by the German Constitutional
Yep.
Court, like social reintegration.
It's in my
And I
piece,
think
yeah.
like even make your argument even stronger. So we have like a very active constitutional law in Europe, and perhaps you could like include it in your research.
It's in there, I promise you. I just didn't mention
okay. No, no, no,
it.
that's
Yeah, so
all.
in the Redeeming Justice piece, I map sort of like, yeah, Germany is one of the
Okay.
pinnacles. In fact, the European Court of Human Rights relies heavily on the German constitutional principle of the social understanding
Okay,
of.
okay. Well, I haven't read the paper, so that's fine.
No, it's all good. I love it. I love it.
Alright.
If there are no further questions, then I'll, everyone please give a hand for our two panelists, Yvette and Rachel Lopez.